My Lord, may I mention unlisted item, case number, WPC number 44 of 2024 to take up the matter today.
Motion?
Yes, for motion.
Yes.
Lordship, may I make a mention for part 2 item 13? It was mentioned yesterday to be listed for today, but due to some difficulty on the part of Mr. B.K. Mahajan, can it be taken up tomorrow? He has requested.
Tomorrow will not be possible. Then you do it next week.
Next week. All right.
Item?
13, 1-3.
Item 13, next week. Yes.
I am obliged.
Yes.
For motion, item number 1.
Yes.
By please, Your Worship.
Yes.
This is a petition challenging the second FIR filed against the petitioner, which was filed on 29th of March 2024, and a crime and economic offence PS case number 3 of 2024 was registered. Prior to that, Your Worship, an FIR was lodged on 20th of March 2024.
Is it connected with item 5 and 6?
Your Worship, yes, in a way they are all interconnected. The other matters are for cancellation of bail orders. This petition is for quashing of the second FIR along with the charge sheet filed against the petitioner. And if I may take Your Lordship to the charge sheet, in both the cases it is copy and paste. There's no difference.
Where is the FIR?
Your Lordship, the first FIR is at page from 14 to 16. The truth type copy is at page 15. So it was submitted by the authorized signatory of Mahindra & Mahindra Financial Services Limited.
This is dated 20th of March 2024.
Yes. The second FIR is dated 29th of March 2024. It is at page 184. The relevant page is at page 187. And Your Worship, it is again by the Mahindra & Mahindra Financial Services Limited. It's regarding separate incidents of the same transaction. And if I may take Your Lordship to the supplementary charge sheet filed by the police in the first FIR, it starts from page 135, annexure 4, and the relevant portion is at page 164. This is the charge sheet filed in the first FIR, ISOL PS case number 96 of 2024. It starts from page 135.
All right. So on what ground are you seeking quashing of the
Your
FIR?
Worship, quashing, Your Worship, the Supreme Court has held that the second FIR, the same transaction, should be quashed. It cannot, two different FIRs on the same transaction cannot be filed. And if I take Your Lordship to the,
Yes, but Supreme Court has also said that in that case it can be clubbed together.
Your Worship, but then Your Worship, if I am convicted in both the cases, it'll amount to double jeopardy.
No. Perhaps you have the decision.
Yes.
Second FIR on the same incident
Yes.
leading to registration of another PS case,
Yes.
that is not permissible.
Yes.
In that case, the Supreme Court has said it has to be clubbed and it has to be one PS case and one GR case.
Yes. So
Is
in
that-
this case, in this matter, Your Worship, 2 FIRs were submitted, 2 police, one ISOL police station, 1 crime and economic offence police station cases were registered.
So I follow you.
Yes.
So if you succeed,
Yes.
at best it will be clubbed. There is no question of quashing.
Okay. And Your Worship,
Do you agree with that?
Your Worship, I'll have to look into that, Your Worship, but because otherwise, if the 2 cases are even clubbed together, and if 2 trials are conducted against me, it may amount that.
No. Let Mr. Mal, let me
Yes.
tell you. Lodging of an FIR, nobody can stop. It
Yes.
is the person, if there is a cognizable offence, the police has to register and proceed to investigate. To that extent, nothing can be done. Only question of prejudice will arise if a person is subject to 2 different proceedings, with regard to the same allegation.
Yes.
So it is in these contexts, the Supreme Court in some decisions have said that in such a situation you have to club the proceedings together so as to ensure that he is not made to suffer two different trials with regard to the same set of facts. Is that your case?
My case is that, Your Worship, that yes, regarding the same incident, 2 FIRs have been submitted, 2 different, one Aizawl police station and 1 crime and economic offence police station cases have been registered. In both the cases, separate charge sheets have been filed. But if we go through the charge sheets, the findings of the case IO is same. It's just copy and paste of the first charge sheet in the second charge sheet.
All right, so in that case it will be clubbed.
Yes.
No
Your- in
question.
fact, Your Worship, there are a couple of other matters also pending on the same subject matter, and notices have been issued.
So today you want notice to be issued?
Yes, today's its motion, Your Worship.
All right. Who is appearing for the state?
I'm here, my lord, for respondent number 3 and my lord friends for the
And
state.
my lord, I'm for the state respondent.
Notice will have to be issued to respondent number 2, the complainant.
In that matter,
All right, and who is respondent number 3?
number 3, Mahindra Lordship. Mahindra.
Mahindra and
Mahindra
Mahindra
and
Financial
Mahindra.
Services Limited.
Yes.
No, but how can you appear? This is a criminal matter.
My lord, I'm
You-
the
you
victim
file your
company.
wakalatnama.
Victim company Lordship. And
That's
I'm,
right, so you file your wakalatnama, notice has to go.
My-
No caveat in
My
criminal
lord, my
matters. Right. Take down, heard Mr. A.R. Malhotra, Learned Counsel appearing for the writ petitioner, peruse the statements made in the petition. By filing this criminal petition, a prayer has been made to quash the second FIR dated
29th of March.
29th of March 2024 with regard to the same incident leading to registration of a different police case being, what is the police case?
Your Worship, the earlier one was Aizawl PS case number 96 of 2024.
And this one,
This one is crime and economic offence police station case number 3 of 2024.
CNEO police case number 3 of 2024, as well as submission of charge sheet dated 25/6/2024
Yes.
on the ground that the second affair is not maintainable on the same set of facts. First up, Mr. Malhotra and Learned Counsel for the petitioner has argued that similar matters in the form of criminal petition number 7/2025 and criminal petition number 8/2025 are pending before this court. First up, in view of the above, issue notice returnable in 4 weeks. Since Ms. Vanaiswamy, learned additional public prosecutor, State of Mizoram, has accepted notice on behalf of the respondent number 1, no formal notice is required to be sent to the said respondent. Petitioner to take steps for service of notice upon respondent numbers 2 and 3 by registered post with AD within a week from today. Heard on the prayer of interim relief, this said prayer will be considered on the returnable date. List along with 7 and 8.
small
criminal-
prayer Lordship, small prayer.
Sorry?
Regarding this matter, my lord, a similar matter has been fixed on 16th of May, my lord. May it kindly become up on 16th of May, lord.
No, it will be listed along with this, along with these 2 petitions. You file your wakalatnama. Today you cannot appear. This is a criminal matter. No caveat lies in.
I agree, lord.
All right, so that's the reason, no problem. You can file your wakalatnama and then take your stand. All right? Yes.
For omission, item number 2.
May I please, Your Lordship?
Yes, who is appearing for the government?
Ms. Vanessa is appearing.
I will be appearing for the government.
You have got the copy of this?
Yes, my lord, I have received it.
Yes.
May I please, Your Lordship. My Lord, as I've stated yesterday, right now, my tenure has ended as my tenure for occupying the drug canteen at Lung Lei Civil Hospital has ended March this year. And I am about to be evicted. And my Lord, at this stage, my humble submission before Your Lordship is at page 34, my Lord. I am protected by condition number 15 and 16 of the conditions set forth by the respondent number 4, my Lord. Condition number 15 is that, if I may read, my Lord, the new awardee operator of the drug canteen must purchase the remaining medicines, medical appliances, and minor consumables from previous awardee operator at the rate they were bought. And 16 is my protection condition, my Lord. The outgoing awardee operator should not collect unnecessary items at the end of the...
All right, we'll issue notice. at
Yes,
this
my lord.
stage. Yes. Notice, that's all.
Yes, my Lord. Notice plus, if Your Lordship may permit me, stay of operation of eviction order dated 11th April, my
It
Lord.
cannot be done. You should have filed an application for injunction. Your application has been dismissed.
Yes, my Lord.
So if you stay that order, what will happen? There will be injunction.
Yes, my Lord.
You have filed an appeal against that order, we'll examine it. But if you want interim relief, then you should have filed an application under Order 39, Rule 1 and 2.
My Lord, I've made an interim prayer in this.
No,
in
you
my
cannot
petition.
make it. See, I am telling you this, you must take note of these things. It cannot happen like this. Appeal is against the order.
Yes, my Lord.
The order is a rejection of your prayer for interim injunction.
Yes, my Lord.
There is no question of stay of that order. If you want an injunction, you have to file a separate application under Order 39, Rule 1 and 2, which you have not filed. This is a civil proceeding, is it not? It's not
Yes,
a
my
writ
Lord.
petition.
Civil proceeding. my Lord.
CPC.
Yes.
So there is a suit and you filed an injunction application. Your prayer has been rejected. So if that order is stayed, what will you get? You are not going to get anything. You need an injunction. That has been declined by the trial court. You have to ask for an injunction before this court.
Yes, and also
Then-
I have prayed for,
And in that injunction, you have to give the schedule, everything. Otherwise, injunction order will not be effective. You check Order 39, Rule 1, 2, 3, you will see that an order of injunction passed in the court is not enough. The notice of injunction has to be served. And from the date of service of notice only it is effective. So you have to give a schedule, you have to give a prayer, what injunction you want. Without that, the order cannot be passed.
yes, my Lord.
That is the law. Right? So I am pointing it out to you so that whether it happens in this case or not, at least these things have to be rectified. Otherwise, later on there is trouble. You file injunction application with the schedule. What is the schedule? Injunction must have a schedule.
Yes, my Lord.
That schedule is what you need to be injuncted. Then if the court allows it, notice has to be issued. Once the notice is served, from that point of time it will be effective. That is the law. And neither you nor this court can change it. You have understood?
Yes, my Lord.
You have to do it. You read the CPC, everything is written there. So the stay order here is meaningless. What is the stay against an order of dismissal? There is no stay. So what to do? Will issue notice?
Yes, my Lord.
Or you want it to be postponed to next week to file an application for injunction? Because if a notice is issued, then it could be troublesome for you. You understood the point.
Yes, my Lord.
Let us fix it on
This Thursday,
first
my
day
Lord.
of next week.
This Thursday, my Lord. In the meantime, I'll file a separate IA.
Yes,
What do
my
you-
lord. If the matter may be fixed after next week, my lord.
Why?
Since Friday is holiday and he cannot do anything.
So, you are Mr.?
Lalbiang no.
Okay. We are not supposed to give legal advice, but
Yes, yes.
for ends of justice, we have to point out something. The order that you can possibly pray for in this case is to make an inventory of your medicines, and that inventory should be protected. The question of stopping the eviction does not arise.
Yes,
That prayer will not be granted.
Yes, ma'am.
So whether you want to rush into this or file a proper application next week, you think about it. After 10 minutes, you tell the court. You make an inventory of all your medicines, goods, etc. We can possibly ask for an order of protection of those medicines, so that tomorrow, once the dispute is resolved, you can get some remedy.
Yes, my lord.
The question of stopping the other side from taking over the premises, not possible in these facts.
By next week, my lord. By next week, 13 or 15. 13 or 15.
13th.
Yes, my lord.
All right, 13th.
Yes, my lord.
But
I'll make a complete
you have understood?
inventory. Yes, my lord.
you make an inventory of
Yes,
the
my lord.
medicines.
Yes, my lord.
Nobody knows, suddenly injunction, not possible. On the prayer of Mr. So-and-so, learned counsel for the, Mr. Lalbhai Khunga Namte, learned counsel for the appellant. This matter is directed to be listed for admission again on 13/5/2025, along with injunction interlocutory application, if any, filed in this case. Ms.
Vani Isyami.
Agor naam to the asile Lanet G. Mizoram is present on behalf of the respondent numbers 1, 4, 5, 6, 7 and 8. So you file a proper application, otherwise it will be meaningless.
Yes, my lord. Yes, my
Injunction will not be implemented.
I'm obliged, my lord.
Yes.
Item number 3.
Item 3. Yes. Yes, who is appearing? Item 3.
Your Lordship, this matter pertains to extension of wildlife sanctuary, and the petitioners have alleged that their Pirikpata falls within that extension area, Your Lordship. And the matter was last listed on the 11th of February 2025, wherein I had sought for time to seek additional information from the concerned state respondents. I have received the additional information and I'll be filing the affidavit in a matter of 2 weeks' time, Your Lordship.
You are appearing for?
State respondents, Your Lordship. Respondent number 1 to 7, Your Lordship.
Your name, please?
K.
Mr.
Roland.
K. Ronald, counsel is present for the writ petitioners. Miss
Lalnun Lu, Your Lordship.
Lanet State Council submits that she has received the additional instruction as called for, and therefore would file counter affidavit on behalf of the state within 2 weeks from today. Since the prayer is not opposed by the petitioner's counsel, same stands allowed. Let this matter be listed again after 3 weeks. In the meantime, counter affidavit be placed on record by serving advance copy upon the petitioner's counsel.
Much obliged, Your Lordship.
Item 4.
Your Lordship, my senior have some personal difficulties. Can the matter be listed again on Thursday? I'm appearing for respondent number 3.
Thursday is not possible. If you want adjournment, it will go to next week.
Maybe after 2 weeks.
Oh, just now you said Thursday, now you say after 2 weeks. Huh?
My senior will not be on station on next week.
No objections, my lord.
Achha, on the prayer of Mr.
Elias Laram Chuna,
Council appearing for the respondent number?
number 3.
Number 3, made with the consent of the other side. This matter stands adjourned for 2 weeks.
Item 5 to 8.
Yeah, Lordship. I'm being led by senior counsel from Delhi, Lordship. So I received instruction for, if possible, my lord, fixing the matter on 16th of May, Lordship.
16th of May. Yes, Mr. Malhotra?
16th, Friday.
Parties and naam to give the names in the list, in a slip. Petitioners Council, then
No, no objection.
APP, Mr. Malhotra for respond number?
Your Worship, I'm in item 6 and
Please
7.
give in a slip the names who is appearing for whom.
Item 6 and 7.
Yes, on the request of learned counsel for the petitioner made with the consent of the other side, let this matter be listed along with other items of ADDBO on 16th of
16th of
May
May.
2025 for admission hearing as fixed items.
Deeply obliged.
Item 9.
Yes,
Your Lordship, this is an application for closure of the contract of the petitioner, late father. The petitioner's late father was a contractor who had died on 3/7/2022. 3/7/2022. There's a clause in the contract agreement for closure of the contract. At page 76, Your Lordship, if I may
page
take a look.
26,
Page 76,
76, yes.
clause 55. Release from performance. 55(2) is the relevant portion, Your Lordship.
Yes,
Death or permanent invalidity of the contractor. The contractor shall indicate his nominee for the contract at the time of signing of agreement. If a contractor dies during the currency of the contract or becomes permanently incapacitated, and his or her nominee are not willing to complete the contract shall be closed without levying any damages or compensation as provided for in clause 44 and 53 of GCC, General Condition of Contract.
yes,
So, the contractor, Mr. Biakliana, is father of the petitioner, and the contractor had died on 3/7/2022, as per the death certificate at page 26. Lordship will see that Mr. Biakliana, the contractor, had died on 3/7/2022. Thereafter, the petitioner
yes,
had submitted an application for closure of all the contracts, which are 11 in number. Lordship. The contract works.
where is the representation? Page 27.
Page. Yes, Your Lordship, I had submitted representations earlier. And thereafter, Your Lordship, the matter was not closed, and I had to file the earlier writ petition. The earlier writ petition was WPC 2 of 2024. It is at page 84. At page 86, paragraph 5, Your Lordship,
Yes,
the Honorable Court, for the sake of convenience, had given all the works in a tabular form. It is stated here, for the sake of convenience, the name of the work, the agreement, the agreed amount, and the relevant remarks as provided by the petitioner in the writ petition is abstracted here under. So there are 11 contract works. And on the last column, the remarks column, there are 3 works which were not completed. 3 works remain incomplete. And in spite of the fact that the works were incomplete, as per the relevant clause of the contract, that is clause 55(1) of the GCC, which I have just read out, Lordship,
Yes.
On the death of the contractor, or on his being permanently incapacitated and his nominee are not willing to complete the contract shall be closed without leaving any damages or compensation as provided for in clauses 44 and 53. So all other works were completed and they are at the stage of maintenance also.
So Mr. Lalram Joba, what has happened to this order after the order of?
After this, Your Lordship, the direction which was given by the Honorable Court is that the petitioner should submit representation again, stating his claim within a specified period.
Right.
And then that is at page 92, Lordship.
Yes.
The petitioner had submitted his claim on 24/7/2024. And the matter was under consideration of the respondents for quite some time, but it was not disposed of during the period given. And thereafter, at page 95, Lordship, the
Yes.
petitioner had to submit yet another representation demanding immediate payment of the claimed amount and foreclosure of the contract as provided. And thereafter, Lordship, as stated here in the body of this writ petition, payments were made at page 17, Lordship, para 6, 17 para 6, Lordship, it has been stated that thereafter, while the petitioner was contemplating filing of a contempt petition due to specific and deliberate violation of the direction of this Honorable Court, he came to know through his mobile phone by way of SMS alert that the following amounts were credited into the bank account at SBI Mission Veng branch in the name of Biak Liana and Sons, operated by the petitioner. So all these amounts were credited on the same date and in the bank account of Biak Liana and Sons, operated by the petitioner. The total amount which has been credited had come to 7,40,79,214. And here, nothing was mentioned as to whether in connection with a particular work this much has been credited or this much has been released. In fact, Lordship, what the petitioner has been praying for is that all the deposits, security and other deposits, which were to be released on closure of the contract, are to be released.
Okay, so your grievance is that the entire amount payable was not released.
Not released.
That is the grievance.
That is the grievance.
All right. Who is appearing for the respondent? Have they filed affidavit here?
They have not filed the affidavit, Lordship.
Why?
Will be appearing for the state.
Sorry? You are appearing?
For the state, yes, Worship.
Oh, what is your stand? Have you filed affidavit?
No, my lord, the only instructions is that as of now, they have requested me to pray for a short time to get the instructions required.
Lordship,
Then they will have to file affidavit, otherwise.
They have to file, that's why they have been given that chance. In spite of that, Lordship, they have been asking for time again and again. Lordship,
Then this time we'll make it final. 4 weeks time with no further adjournment on this ground. Heard Mr. C. Lalram Joba, Learned Senior Counsel, assisted by Mr. Peruse the averments made in the writ petition. Miss Mary L. Khengte, Learned Government Advocate for the State of Mizoram, appearing for the respondents, has prayed for further 3 weeks time to obtain instruction and file affidavit. Resisting the said prayer, Mr. Lalram Joba, Learned Senior Counsel for the petitioner, submits that the respondents have already availed a number of adjournments for filing affidavit, thus causing serious injury to the interest of his client. Full stop. Taking note of the submission made by learned counsel for both the sides, this writ petition stands adjourned for 4 weeks so as to grant one final opportunity to the respondents to file affidavit. It is made clear that if the affidavit is not brought on, counter affidavit is not brought on record within 4 weeks from today, the writ petition will be taken up for disposal on the basis of materials available on record. Let the matter be listed accordingly. Yes. Please file your affidavit, Ms. Kante.
Item 10.
My lord, as per the last court order, we have taken steps. However, my lord, the state have filed a case in Supreme Court and this contempt has been stayed, my lord.
The order has been stayed.
Yes, my lord.
Let us see. Your name, please?
Ropari.
नाम तो लिख दीजिए. So and so learned counsel for the petitioner has produced a copy of the order dated 17/4/2025 passed by the Honorable Supreme Court in SLP bracket civil bracket close diary number 10724/2025 to submit that the order of the court has been stayed and therefore the contempt proceeding be adjourned awaiting final order in the pending SLP. Full stop. In view of the above, this matter stands adjourned for 6 weeks.
Obliged.
Where is the order of the court which has been stayed?
The order is WPC.
Page? Which order has been stayed by the Supreme
Page
Court?
number 13 to 49. 13 to 49, my lord.
13 to 49.
WPC 130 of 2013, the common judgment and order.
So this is an order by the single judge, learned single judge.
Yes, my lord. However, the state have filed a writ appeal and that was dismissed.
It has filed writ. Where is the writ appeal?
The writ
Order passed in writ appeal, where is it?
Order is at Annexure 2, page number
Page number?
50 to 156. And the
50.
relevant portion is the relevant portion is at para number 154, my lord.
List accordingly, yes.
Obliged.
For orders, item 11.
Lordship, in this matter, the office note indicates that the service report on the respondent number 1 to 3 is not returned till date, Your Lordship. So they are from the remote villages, Your Lordship. We may wait for some
Wait
other
for some
time.
more
Yes,
time.
Lordship.
Yes. Your Mr.
Johnny L. Tau Chong.
Mr. So-and-so, Learned Counsel is present for the petitioner. Office note dated 5/5/2025 indicates that service report on the respondents is still awaited. Awaiting service report on the said respondents for further 3 weeks. This matter is directed to be posted
Lordship,
again
yes.
after 3 weeks with appropriate office note.
Item 30.
May it please Your Lordship, again, notice was issued on 13th of February, but till date, AD card has not been received back. Your Lordship, we may make a fresh attempt,
Fresh steps.
maybe.
On the request of Mr. A.R. Malhotra, Learned Counsel for the petitioner, appellant, leave is granted to the appellants to take fresh steps for service of notice upon the respondents.
Respondent
Steps-
1.
Respondent number 1. Steps, other respondents have been served.
The state.
Steps by registered post with AD within a week from today. The Learned State Council for the state of Mizoram is present on behalf of respondent numbers 2 to 5. 2 to 6. 2 to 6. Learned State Council, Miss, your name please? You are appearing in this?
My lord, I'm appearing in the matter.
You are appearing? अच्छा त्यतिले to the Miss Mary L. Khainte, Learned Government Advocate for the state of Mizoram, is present on behalf of the respondent numbers 2 to 6.
Your Lordship, in the meantime, the records have arrived. Paper book may be prepared.
In the meantime, since the LCR has already been received, registry may expedite preparation of paper book
At the cost of the appellant.
at the cost of the appellant. Mr. Malhotra, Learned Counsel for the appellant, undertakes to do the needful.
Item 14 and 15.
Yeah, please, Your Lordship. This is an application under Order 22 Rule 3 for read with Section 151 of CPC for substitution of this is appellant number 1.
Notice has been issued here. No notice has been issued here.
Not first time.
So today we have to issue notice. Who is for the respondent?
State.
Yes, Your Lordship. State respondent.
No problem.
You have no objection?
No, Your Lordship.
All right. Then we can allow it.
Yes, Your Lordship.
The petitioner, main writ petitioner has expired.
Yeah, the appellant number 1.
Appellant number 1, sorry, yes.
And she will be represented by the appellant number 2. It's her brother and his brother.
Okay, appellant. So you heard Mr.
K. Roland. K. Roland.
K. Ronald, Learned Counsel for the applicant. Also heard Miss, who is appearing?
Lalnan Lu, Your Lordship. For respondent number 1 to 5, Your Lordship. State respondent.
So and so, Learned Counsel appearing for the respondent numbers 1 to 5. This IA has been filed with a prayer to substitute the original appellant in the appeal, who is stated to have expired on 23/1/2025. Full stop. The applicant is the brother,
Yes, ma'am.
brother of the original appellant, and submits that 7 except the applicant, there is no other surviving legal heir
Yes.
of the deceased appellant.
She's unmarried.
Huh?
She's unmarried.
Because she died unmarried. Full stop. That apart, according to the applicant, the right to sue still survives, and therefore the application for substitution deserves to be allowed by this court. The Learned Counsel for the opposite parties, Ms. So-and-so, submits that she would have no objection if the prayer for substitution is allowed by this court. In view of the above, the prayer for substitution of the original appellant in this case by the applicant, namely Sri applicant naam to Dirghoham so and so, is hereby allowed. Appellant to file amended cause title. Let the appeal, connected appeal be listed thereafter for orders. IS stands disposed of.
Much obliged, Your Lordship.
Supplementary cause list for motion. Item number 60.
So, who's the petitioner? Father?
Yes, Father. My Lord, this is regarding the challenging the order dated 24/4 of 2025 passed by the Lanat Additional District and Session Court in guardianship certificate number 61 of 2025.
Where is the order? Which page?
It is in page 47, my Lord.
47.
Then the operative part is in page 40. It is starting from page 48.
Nine months.
Now the infant is only 9 months, but at the age of the reason why we submitted this repeated this case is it is in page 28. My Lord, please take page 28.
9 months. How will the father get it? It will be with the mother. Anyway, we'll issue notice at this stage.
My Lord, in the meantime, I would like to submit that at the age of 6 months only, the infant was kept to me by the mother of the infant with her own desire.
All right, so today what do you want?
Today we want to stay the operation, to maintain the status quo before the passing, passing order dated 24
All
for
right, we'll issue
2025.
notice today and on the interim prayer also. You can serve dusty notice.
Yes, my Lord.
All right.
Then in the meantime, my Lord, to stay the operation of 24 for 2025 and to maintain the status quo before passing such order.
You're Miss Rashila?
I'm Jacinta Zotan-Moye.
Can you please repeat the name?
Jacinta Zotan-Moye.
Heard Miss
Jacinta
Zotan-Moye, Learned Counsel for the writ petitioner. Peruse the amendments made in the writ petition. This writ petition instituted by the father of an infant is directed against the order dated 24/4/2025 passed by the Court of Additional District and Session Judge, Aizawl, in connection with guardianship certificate case number 61 of 2025, granting custody of the 9-month-old minor child to the respondent, that is the mother, with a direction to hand over the minor child to the respondent full stop. Ms. So-and-so, Learned Counsel for the petitioner, submits that prior to the issuance of the impugned order, the child was in the custody of the writ petitioner. Hence, status quo be maintained, full stop. Status quo as on date be maintained, full stop. Issue notice returnable on 19 5/2025. Petitioner to take steps for service of notice upon the respondent by registered post with AD during the course of the day. Today only you have to take steps. That apart, the petitioner
Within 2 days, my lord.
today.
Yes, my
If you
lord.
want interim order, today only you have to take steps.
Okay, my lord.
In addition to the above, the petitioner is also granted liberty to serve dusty notice upon the respondent, heard on the prayer of interim relief, having regard to the overall facts and interim relief, the said prayer will be considered on the returnable date. However, having regard to the overall facts and circumstances of the case, as an ad interim measure, it is provided that status quo as regards the custody of the child as on date be maintained till the returnable date.
Mr. Bryce.
Part 2, item number 6.
Item number? Yes.
May it please your Lordship, this is a first appeal against the judgment passed by the trial court in declaratory suit number 27 of 2012. Yep, the dispute is it's with regard to inheritance of the property of the deceased between the second wife and the son from the first wife.
Yes.
Your, at the outset, in the paper book, Your Worship, the judgment has the pagination is wrong. This page 117 of the paper book.
The records are, LCR is available here.
This page 117
Yes.
should be placed between 119 and 120.
Oh.
If Your Lordship will see at page 116, the last sentence.
Then it has to be corrected.
Yes.
Pagination.
If Your Lordship will kindly see, yes, just to clarify to Your Lord, page 116, the last sentence.
Page 116, yes.
Your Lordship, the last sentence, second last line. She denied to the suggestion that the plaintiff being the youngest son of the deceased, if Your Lordship will go to before the marriage was known. So it does not connect.
So you have to rectify it.
Yes, sir. 117 has to be placed between 119 and 120.
Then you rectify it.
Well,
Mr. A.R. Malhotra, Learned Counsel for the appellants, yes, he has to rectify it. So that means that there is some defect in the paper book which calls for rectification. In the rectification, it has been pointed out that page 117 in the paper book has been wrongly inserted therein. Full stop. Mr. Your
Joseph, Mr. Joseph, my lord.
Mr. Joseph, Learned Counsel is present for the respondent. In view of the defect pointed out in the paper book, registry to look into the matter and carry out necessary rectification. Let the appeal be listed for hearing again after the defect is rectified. Learned Counsel for both the sides to render necessary cooperation in this regard. That's all. Now, what about the other?
My lord, my lord, there is one other matter. Let me see, my lord.
Yes. There is one.
My lord, let these other matters, my lord, will make a mention tomorrow. We'll check, my lord, because one of the there is one other matter, my lord. This one is with, but the opposing counsel is not present today, my lord. It's my matter.
We'll mention it on Thursday. I think tomorrow is division day, bench matters.
Your system is a little different, and I don't want to change the system coming for a week. I have been briefed
Yes.
what to do. we'll respect your existing system.
Issues number one.
I think so because she denied to the suggestion that the criminal of the deceased before I knew it around.